Okay, good morning, ma'am. Please state your name.
Reynaldo Garcia.
Ms. Garcia, you are here for a first appearance today of the charge of battery. You have the right to remain silent. Anything that you say may be used against you. You also have the right to communicate with counsel, family, and friends. Do you understand what I'm saying today, ma'am?
Judge, I think she'd prefer Spanish interpreter.
Certainly. One moment, please. Madam Interpreter, are you still on the line?
Yes, and I'm also connected to the podium.
Okay, thank you.
You have the.
Sí.
There's Your Honor.
Ma'am, you have the right to remain silent. Anything that you say may be used against you. You also have the right to communicate with counsel, family, and friends, and you have the right to an attorney. Would you like me to appoint the Office of the Public Defender to represent you today? Okay, at this point in time, I will appoint the Office of the Public Defender to represent you. I am finding that there is probable cause in this case. Good afternoon, sir. Is there something that you wanted to bring to the court's attention?
No.
Do you wish to say anything today, sir?
No.
Okay. Let's see. At this point, having reviewed what I have, I am going to, is there anything that needs to be added to the phase sheet?
No, it's, prints are back and everything's on there, Your Honor.
Okay. All right. Thank you. At this point, I am going to set bond in the amount of $500. Ma'am, do you reside with the alleged victim?
No.
Okay. So at this point, ma'am, I'm going to order that there is no contact with the alleged victim. Do you understand? You're to have no contact whatsoever. Have a nice day, ma'am.
Yeah.
William, Mr. Ramos, bonded?
Bonded? Okay, so sir, you may approach and state your name for the record. Will you state your name for the record, sir?
Herman Daniel Herrera Canelas. Herman Daniel Herrera Canelas.
Mr. Carneras, you are here for a first appearance today on the charge of battery. You have the right to remain silent. Anything you say may be used against you. You also have the right to speak with counsel, family, and friends, and you have the right to an attorney. Would you like for me to appoint the Office of the Public Defender to represent you today?
Yeah.
Okay, at this point, I will appoint the Office of the Public Defender to represent you. I am finding that there is probable cause in this case. I'm going to set your bond amount at $500, sir, and I'm going to order that you have no contact whatsoever with the alleged victim.
Okay.
You understand what no contact means, sir?
Yeah.
Okay, have a nice day, sir.
Thank you.
Approach. Okay. Okay. Madam Interpreter, I think that's all we have for you this morning. Thank you for your assistance.
And Your Honor, before I leave, do any of the witnesses need the Spanish interpreter?
Does anyone in the room need a Spanish interpreter? I see a lot of heads shaking no.
Okay.
Thank you, ma'am. You have a nice day.
Thank you as well.
Sir, would you please state your name?
Pretty Brown.
Okay, that's not who I have. Freddie Brown, okay. What happened? Okay, one moment, Mr. Brown. Where is Carl Dockman?
Mental health, Your Honor.
Mental health? Okay, so he'll need to be reset? Okay. All right. Mr. Brown, you are here for your first appearance on the charge of aggravated assault with a weapon. You have the right to remain silent. Anything that you say may be used against you. You also have the right to communicate with counsel, family, and friends. You have the right to an attorney. Would you like for me to appoint the office of the public defender to represent you?
If you wish, you know,
Is that I'm sorry?
if you wish.
Would you like them? Yes or no, sir?
I was at the belief that they already had done waived over on the opposite side.
Sir, would you tell me yes or no whether you would like for me to appoint them? I'm just having trouble understanding, I think, with the mask on.
Oh, yeah, whatever procedure it takes, you know, I don't mind.
He said whatever procedure it takes, I don't mind.
Okay. All right. Then I will go ahead at this time, thank you, counsel, and appoint the office of the public defender to represent you. I am finding that there is probable cause in this case. I am keeping the amount of bond at $1,500. Sir, you are to have no contact with the alleged victim. Do you understand what no contact means?
Mm-hmm.
Okay. Sir, you are not to have any firearms. Any firearms that you do have need to be surrendered to law enforcement. Do you understand?
Mm-hmm.
In addition, sir, you are not to have any illegal substances. Do you understand?
Mm-hmm.
Okay, have a nice day, sir. Sir, will you please state your name for the record?
Sean Jones?
Mr. Jones, you are here for your first appearance on the charge of trespass on property after a warning. You have a right to remain silent. Anything that you say today may be used against you. You also have the right to communicate with counsel, family, and friends, and you have the right to an attorney. Would you like me to appoint the office of the public defender to represent you?
Yeah.
Okay, at this point in time, I will appoint the office of the public defender to represent you. Sir, I am finding that there is probable cause in this case. I'm setting your bond amount at $500. In addition, sir, you are not to return to the property. Do you understand that?
Yeah.
Okay, thank you, sir. Have a nice day.
Okay. Do you want to do it this way?
Sir, please state your name for the record.
Nelson Fernandez.
Mr. Fernandez, you are here for a first appearance on the charge of trespass on property after a warning. You have the right to remain silent. Anything that you say today may be used against you. You also have the right to communicate with counsel, family, and friends. You have the right to an attorney. Would you like me to appoint the office of the public defender to represent you?
Yes.
At this point, I will appoint the office of the public defender to represent you in this case. I have reviewed the affidavit of arrest. I am finding that there is probable cause. I am setting your bond in the amount of $500. In addition, sir, you are not to return to the property. Do you understand that condition?
Yes, I do.
Okay, have a nice day, sir.
No.
Judge,
Yes, counsel.
I'm sorry, based on Mr. Fernandez's inability to afford the monetary bond, I'm asking for R or PTR, given the non-violent nature of the charge and the presumption in favor of non-monetary.
PTR?
He does not qualify. He does have a history of mental health PTRs and Baker Act, so Your Honor.
Could we do bond or mental health PTR if he qualifies? That way they'll screen him, and if he qualifies, he'd be released, but if he doesn't, then your bond order would remain in place.
Okay, we'll go ahead and get him screened for that. And in the event he does not qualify, the bond is going to be set at the $500. And then again, sir, you are not to return to the property.
Not wrong.
Have a nice day, sir.
Thank you.
No stipulations with that, Your Honor, for the order for the mental health? Just mental health PTR?
Yes. He's just to be screened for that, correct? And then if he does not qualify, he gets out on, or the bond is imposed.
Yes.
Okay, sir, I'm sorry?
Thank you, Your Honor.
Okay. Just let me know if you need any further information from me. Please state your name for the record, sir.
Slavik Wang.
Mr. Lang, you are here for a first appearance on the charges of grand theft and battery and dating violence. You have the right to remain silent. Anything that you say may be used against you. You also have the right to counsel, to speak with, you have a right to speak with your counsel, your friends, and your family. You have the right to an attorney. Would you like me to appoint the Office of the Public Defender? At this point in time, I will appoint the Office of the Public Defender to represent you in this cause. In addition, I am finding that there is probable cause in this case. One moment, please. Okay. Okay, I am setting your bond in count 1, which is grand theft, at $1,000. Count 2 for the battery of dating violence at $500. Sir, you are to have no contact whatsoever with the alleged victim. Do you understand what no contact means? Okay. And then in addition, you are to have no firearms. Do you understand that, sir? Have a nice day, sir.
Your Honor, may he have a one-time return with law
I
enforcement?
can pay this.
Oh, apologies. Do you reside with the alleged victim? Or counsel, does he reside with the alleged victim?
My recollection from the back is that he needed a trip to gather belongings. I'm not, do you,
No, I don't live there. No. I live in my house.
okay,
Myself.
do you have?
What
anything
notes
there?
we have, Your
No,
Honor?
we
Oh,
separately.
okay, then I mixed him up with someone else. Sorry. We
Yeah.
can strike that.
Yeah. So I go pay $1,500. What do I do next?
Yeah, they'll show you in the back.
And then you are to have no contact with her. Do you understand?
Yes. Thank you.
Okay, the next, sir, please state your name.
Your Honor, I'm Alejandro Martinez Moreno.
Okay, Mr. Moreno, you are here for your first appearance for the charges of tampering with a witness and battery of domestic violence. You have the right to remain silent. Anything that you say may be used against you. You also have the right to communicate with counsel, family, and friends. You have the right to an attorney. At this point, would you like me to appoint the Office of the Public Defender to represent you?
Yes, please.
Okay, I will go ahead and appoint the Office of the Public Defender to represent you. I have reviewed the arrest affidavit. I am finding probable cause. In addition, I see that there is a witness here. Sir, would you like to make a statement to the court?
Yes.
Okay, raise your right hand, please, to be sworn.
Do you swear or affirm that testimony about to give should be the truth, the whole truth, and nothing but the truth?
I swear.
Please state your name for the record and spell your last name.
Eduardo Penaran. Penaran.
Sir, what is it that you would like the court to consider?
Well, I was the alleged victim in this case, and I just wanted to let the court know that under Alejandro, he is not normally like this when he's not drinking. This happened while he was not sober, and under normal circumstances, he doesn't behave this way with me. So I just want to let the court know that I don't want to press any charges or do any of that. I just want to resolve this, and without the law getting involved, I just felt unsafe when that happened. But I wouldn't feel threatened right now.
Do you reside with him, sir?
Yes.
Do you wish to have contact with him?
Yes.
Are you afraid of him?
No.
State, would you like to inquire?
Yes, Your Honor. Could you describe your relationship with Mr. Moreno?
We're married.
Sorry?
We're married.
Okay, and has anything like this happened in the past?
No,
Do you expect that it could happen in the future?
I don't think so.
Okay.
Defense, would you like to inquire?
No, Your Honor.
Okay. Thank you, sir. I appreciate you coming today. At this point, one moment, please. Go over. Okay, at this point, on the first count of tampering with a witness, I am going to set bond in the amount of $500. As to the domestic violence charge, the battery, I am going to set bond in the amount of $1,000. In addition, sir, you are to have no hostile contact with the alleged victim. That means you can have contact based on what I have heard today and what I have reviewed, but you can have no hostile contact with him. Do you understand that?
Yes, Your Honor.
In addition, you are to not consume any alcohol for the time being. Do you understand that?
Yes, Your Honor.
You may also have no illegal substances. Do you understand that?
Yes, Your Honor.
Okay, you are also to have no firearms. Do you understand that?
Yes, Your Honor.
Have a nice day, sir.
This is for you. Here you go, sir.
Good afternoon, ma'am. Please state your name.
Kelly Tallman.
And just so everyone's aware, before you bring the next person in, we're going to take a 10-minute break after this appearance. Okay, Mr. Tallman, or Ms. Tallman, you are here for your first appearance on the charge of cruelty towards a child and battery. You have the right to remain silent. Did you want me to repeat the charges, ma'am?
Please.
Okay. The first charge is listed as cruelty towards a child. It's child abuse without great bodily harm. The second charge is battery. It's a domestic battery charge by strangulation. You have the right to remain silent. Anything that you say may be used against you. You have the right to communicate with counsel, family, and friends. You also have the right to an attorney. Would you like for me to appoint the Office of the Public Defender to represent you at this time?
Please.
Okay, I'm going to go ahead and appoint the Office of the Public Defender to represent you. I have reviewed the affidavit. I am finding probable cause in this case.
Judge, may I make a brief argument before
Yes.
you move on? I have probable cause concerns with respect to the strangulation. One of the necessary elements is the restriction of airflow, and I did not see that named in the affidavit as to that charge. Additionally, with respect to the child abuse, there was no age listed of the alleged victim within the four corners of the affidavit.
But she is the legal guardian of the alleged victim, is that correct? Based on the allegations?
That's what the officer
Is
in
alleging.
the affidavit, yes, Your Honor.
State want to be heard?
Your Honor, if the state accepts the objection, then I would just ask for 48 hours to provide a supplemental report.
Your argument is that she could still breathe, is that correct?
Yes. So essentially, if the court is going to find PC, it would, my opinion is that it would have to be as to the misdemeanor battery.
Okay, so tell me the elements for strangulation, counsel.
Touching without consent. I don't know the exact verbiage. I could look at it, but it's essentially that the airway is restricted to the point where the person can't breathe.
Says that there's allegations at least that she grabbed her by the neck and squeezed, making it difficult to breathe, but not cutting off the airflow.
Yeah, so I think that's the last part of that sentence is why I think it does not rise to the level of PC.
Okay, at this point, I will afford the state 48 hours to supplement.
Thank you, Judge.
Have a nice day, ma'am.
I don't know if, I think I interrupted you before we got to the bond amounts.
Well, I need to wait, don't I, until the state supplements? Let's see. Otherwise, you want me to set them before the state supplements because it might be on a charge that, okay,
Yes, Your Honor.
all right. Where did I? Okay, as to count one, cruelty of a child, the bond amount, oh, where's the phase? One moment, please. I've gotten out of sorts here. Okay, the cruelty toward a child is going to be set at $1,000. And the battery by strangulation is going to be set at $2,500. In addition, is she still living? I'm imposing no contact. My concern is if she's the legal guardian, so are the two residing together?
You live somewhere else.
I can live somewhere else. No, I do.
Oh, yeah. So she does live there, Your Honor, but she has a secondary residence she can stay at. Are you the guardian or is your mother
My
the
mother.
guardian? It's, so I think it's technically the great-grandmother
Grandmother.
that's the guardian. So
Okay.
she's not the guardian.
Okay, so ma'am, you are to have no contact with the alleged victim. Do you understand that? So if you do you need to return to the property? I understand that you have a second location. Do you need to obtain personal items? Okay, so I will allow you a one-time return to the property. When you do that, you must be accompanied by law enforcement. You may not coordinate that visit with the alleged victim. Do you understand? You'll have to coordinate that through someone else because you are to have no contact with her, okay? In addition, ma'am, you are to have no illegal substances. Do you understand? Okay, have a nice day, ma'am. Sorry? Yes.
She said no contact.
Okay, and then,
Not about
court's going to be in recess for 10 minutes, so we will come back around 1:15, 1:16. Coach, and state your name.
Lisa Bell.
Okay, good afternoon, Miss Bell. You are here for a first appearance on the charge of battery. You have the right to remain silent. Anything that you say may be used against you. You also have the right to communicate with counsel, family, and friends. You have the right to an attorney. Would you like me to appoint the Office of the Public Defender to represent you today?
Yes, ma'am.
Okay, at this point, I will appoint the Office of the Public Defender to represent you. In addition, I have found that there is probable cause. Let's see, I am going to, one moment, let me see. Okay, at this point, I am going to set bond in the amount of $1,000. In addition, I am ordering that you have no contact with the alleged victim in this case. But do you reside with the alleged victim? Okay. Do you have any belongings or anything that you need to go and get? Okay, so you are going to have no victim. You're going to have no contact with the alleged victim. In addition, you are to have no illegal substances. Do you understand that? Okay, have a nice day, ma'am. Please state your name for the record.
Christian Leon Roberto.
Okay, Mr. Roberto, you are here for a first appearance on the charge of battery. You have the right to remain silent. Anything that you say may be used against you. You also have the right to communicate with counsel, family, and friends, and you have the right to an attorney. Would you like me to appoint the Office of the Public Defender to represent you?
Please.
Okay, at this point, I'm going to appoint the Office of the Public Defender to represent you in this cause. One moment, please. Okay, I'm going to set bond in this case at $5,000. In addition, sir, you are to have absolutely no contact with the alleged victim. Do you understand no contact?
Yes, ma'am.
Okay. In addition, sir, you are to have no firearms. If you have any firearms, they need to be surrendered to law enforcement. Do you understand?
Yes, ma'am.
You are to also have no illegal substances.
Yes, ma'am.
Do you reside with the alleged victim?
Yes, ma'am.
Okay, so what I will allow is a one-time return so that you can get your personal belongings. When you return to get your personal belongings, you have to be accompanied by law enforcement. In addition, when you go to schedule that return to grab your stuff, you may not schedule that with the alleged victim. Do you understand?
Yes, ma'am.
Okay, so you cannot communicate with the alleged victim at all, and I'll give you a one-time return.
Yes, ma'am.
Have a nice day, sir.
Thank you.
Please state your name for the record, sir.
Joshua Limberhand.
Mr. Limberhand, you are here for a first appearance on the charges of resisting an officer without violence, assault on a law enforcement officer, and battery, domestic violence. One moment, please. You have the right to remain silent. Anything that you say may be used against you. You also have the right to speak with counsel, family, and friends, and you have the right to an attorney. Would you like me to appoint the office of the public defender to represent you?
Yes, ma'am.
Okay, at this point, I will appoint the office of the public defender to represent you. In addition, I am finding that there is probable cause in this case. One moment, please. Okay, for the charge of resisting an officer without violence, I am keeping that bond amount at $500. As for assault on a law enforcement officer, I am keeping that bond amount at $100. One moment, please. And as for the charge of domestic battery, I am setting the bond amount at $1,000. In addition, sir, you are to have no contact with the alleged victim. Do you understand that?
Yes, ma'am.
Am I correct that you do not live together?
No, we're sleeping on the streets, ma'am.
I'm sorry?
We're homeless.
They're sleeping on, they're homeless, Your Honor.
Okay. Okay, you are to have no contact with the alleged victim. Have a nice day, sir. Oh, yes. Good afternoon, sir. Will you please state your name for the record?
Rohan Phillip Jr.
Okay, Mr. Phillip, you are here for a first appearance on the charge of battery, domestic violence. You have the right to remain silent. Anything that you say may be used against you. You also have the right to speak with counsel, family, and friends. You have the right to an attorney. Would you like me to appoint the office of the public defender?
Yes.
Okay, at this point, I will appoint the office of the public defender to represent you. In addition, I am finding probable cause in this case. It looks like, let's see here. It looks like there's a second case. Is that correct?
Yes.
It looks like there's the battery and then there's also a DUI. Is this just an add-on?
It's a first appearance detainer for being out on bond, Your Honor.
You were out on bond on the DUI. Well, I'll ask your attorney. Was he out on bond on the DUI
Yes, Your Honor. That's
when the
correct.
domestic battery offense allegedly occurred?
That's correct.
Okay. Would the defense like to be heard?
Yes, Your Honor. Thank you. With respect to that CT case, the DUI, Mr. Phillips does have private counsel,
Okay.
Joel Leopard. So we would not be asking for the PD to be appointed on that case, but just generally for argument's sake, Mr. Phillips is asking that the court take no action on that case. These two offenses don't appear to be related or similar in nature, and he also has his own apartment, car, and job where if the court were to revoke bond, he would unfortunately be in a position where he would lose his job and potentially be evicted from his apartment.
Would the state like to be heard?
No, Your Honor.
Okay, ma'am, did you wish to be heard today?
Yes.
Okay, would you please raise your right hand to be sworn?
Do you swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name for the record, spell your last name.
Kiera Fells,
Spell your last name, please.
Fells.
Ma'am, what would you like for the court to consider today?
I would like to drop charges. Rohan is doing really well for himself, and this was just the first situation where I didn't feel safe, but I do have personal belongings that I would like to get. I would just like to leave the relationship in peace.
Do you live together?
No, but I'm there a lot.
Okay, so you have personal belongings at his house. Do you wish to have contact with him?
I can't say right now.
Okay. State, would you like to inquire?
Yes, ma'am, could you describe your relationship with Mr. Phillip?
We were friends for 2 years, and we have been dating since January.
Okay, has any incident like this happened in the past?
No.
Would you expect this kind of incident to happen again in the future?
No.
No further questions, Your Honor.
Defense?
No, Your Honor.
Okay. All right, at this time, I am going to revoke bond. You were out on bond, sir, when the new offense occurred, so I am going to revoke bond in this case. Your private attorney can make any future arguments on your behalf. I'm sorry? Oh, for the, on the battery, I'm going to set the bond at $1,000. The conditions are going to be at this time that you have no contact with her whatsoever, sir. Do you understand?
Yes, ma'am.
Okay, let's see. In the event that you would like to get personal belongings, let's see. He is either not going to be able to be in the house when you do that, or you're going to need to be accompanied by law enforcement. Do not schedule that visit with one another because he cannot have any contact with you, okay? I wonder if, one moment, please. Trying to figure out, practically speaking, how this would work. Do you have a key to the apartment?
No.
Counsel, do you have any recommendations on how she can get her stuff out of his apartment without making contact with him?
I think to be safe, if she doesn't mind the court just ordering law enforcement to be present, that way any kind of logistical issues aren't issues.
Okay, here's what I'm going to order, that you contact law enforcement in order to go get your belongings, and that, sir, you cannot be inside the house when she is inside the house getting her personal belongings, okay? This will just be one time, so get everything that you need, okay?
Okay.
All right, you all have a nice day. Wait, one moment. Sir, sorry, in addition to the no contact order, you are also not to have any firearms or illegal substances. Do you understand?
Yes, ma'am.
Okay, have a nice day, sir. One moment, please. Let's see if she's still in the building. Tell me her last name.
Else.
Is she left the building?
Probably not yet. You can call to see if she's still making the.
My concern, I have a jurisdictional concern regarding her coming back and my ordering her to only come back certain times. State, do you have any input?
I'm sorry, Your Honor. I guess the question is still with the logistical issue with whether
Yes.
she can attend or whether she can go to his house without him present, right? I have no input. This is a kind of a strange situation. Usually it's
The reverse.
the reverse.
Yes, that's what I'm struggling with. Defense?
Yeah, I see the issue now that I've played it back in my head.
One moment, please.
The issue is his apartment, so he has the right to be at his apartment. He just can't have any contact with her. He can be there, but the police have to come with her to make sure that nothing happens.
The issue though is the judge doesn't have jurisdiction over anyone but the defendant. I mean, I think it's a civil issue that she would have to take up with somebody, just, you know what I mean? We have no objection to what the court ordered, though.
Yes.
Possible third party picking up her stuff
Right.
would handle it.
Which the other problem is, he's no bond in jail, so.
She doesn't have a key. Well, logistically, I think that it makes the most sense to have, since there's a no contact order, to have a third party go and get the stuff. So I hate to amend it without, we want to bring him back in so that I can amend it while he can hear the court. I mean, I can't bring her back in, so the order is just going to be what the order is. But I don't want to exceed my jurisdiction, notwithstanding the lack of objection.
Maybe a few minutes. You're getting it now.
Okay.
We could call Mr. Semenoff and circle
Okay.
back. If
Yes. Please state your name for the record, sir. Mr. Semenoff, you are here for a first appearance today of the charge of battery of domestic violence. You have the right to remain silent. Anything that you say may be used against you. You also have the right to speak with your counsel, family, and friends. You have the right to an attorney. Would you like me to appoint the Office of the Public Defender to represent you today?
Yes, please.
Okay. At this point, I will appoint the Office of the Public Defender to represent you. I am finding probable cause based on the arrest affidavit. Does pretrial release want to bring anything to my attention on this?
Let's see, we were unable to contact the victim in this, and then it doesn't really say, it just says that there was an alternative address provided, but they did not qualify him for PTR.
Okay. No criminal history?
His fingerprints are back, and there was no criminal history found, Your Honor.
Okay. At this time, I am going to enter a bond amount of $1,000. In addition, you may have no contact with the victim in this case. Do you understand what no contact means?
Yes,
Do you live with the alleged victim?
yes, the house, bought on my name, I'm paying the mortgage, yes.
Okay, is there another address where you can stay?
I can stay with the friends.
Okay, I'm going to allow you a one-time return to the property to gather personal belongings, but you have to be accompanied by law enforcement when you return. And in addition, you cannot you cannot schedule that return visit with the alleged victim because you have no contact. Do you understand?
I understand. How it would be done then? Through the third party?
Yes, you could do it through a third party. That will be just fine. Okay? Have a nice day, sir.
Thank you.
Is that bond amount of $1,000? The third party's going to communicate about the return. Yes.
Oh, okay.
To be coordinated with. I said third party.
Oh, okay. Yeah, that sounds like.
Okay, sir, let's see, one moment, please. Sir, would you please state your name again for the record?
Rohan Phillip Jr.
Okay, sir, I wanted to clarify something. Logistically, your case was a little bit unique because she has items, the alleged victim meaning, has items at your residence. And oftentimes we see that in the reverse. So we were thinking logistically about how to do that. I'm concerned because I issued orders in that case with regard to her, and I'm concerned about my jurisdiction over her, okay? So what my order is going to reflect with regard to her return visit is that that be coordinated through a third party, okay? So you all can schedule that through a third party. You cannot have contact with her still. All of my other conditions that I have imposed remain. It's just that she is not going to communicate with law enforcement and then go to your house. She's not just subject to one more visit, okay? Yes.
Your Honor, I understand everything that's going on. If I don't get out of here, I will be homeless and lose my car and lose everything. I wanted to know if you could raise my bond instead of revoking it, and I can have someone help me out on the outside.
Okay, the court's concerned at this time because you were out on bond already. And so I'm concerned about the conditions that I could impose today that would make you comply because there was a new law violation allegedly that occurred while you were out on bond. So for the safety of the community and to ensure compliance, I do have to revoke that bond today. Okay. Good luck to you, sir. Good afternoon, ma'am. Would you please state your name for the record?
Angelique Warner.
Ms. Warner, you are here for a first appearance on the charge of battery of domestic violence. You have the right to remain silent. Anything that you say may be used against you. You have the right to communicate with counsel, family, and friends, and you have the right to an attorney. Would you like for me to appoint the Office of the Public Defender to represent you today?
Yes.
Okay. At this point, I am going to appoint the Office of the Public Defender to represent you. In addition, I am finding that there is probable cause in this case. Okay, at this point, I am going to set bond in the amount of $2,000 in order that you have absolutely no contact with the alleged victim. Would the defense like to be heard?
No, Judge, I apologize for distracting her. I was
That's okay.
just making sure she could afford that amount. I have no argument at this time.
Okay. All right, so bond is going to be set at $2,000. You are to have absolutely no contact with the alleged victim. You understand what no contact means?
Yes, ma'am.
Do you live with the alleged victim?
Yes, ma'am.
Okay, so what I will allow is for you to have a one-time return visit so that you can collect your personal belongings, but you must be accompanied by law enforcement, and you cannot coordinate that through her, okay, or the alleged victim, rather. And so that will need to be coordinated through someone else or through law enforcement. In addition, you're to have no illegal substances. Do you understand that?
Yes, ma'am.
Okay. Have a nice day, ma'am. Okay, please state your name for the record.
Jennifer Claveau.
I'm sorry?
Jennifer Claveau.
Okay, what about Latanya Bacedo?
You don't have the name of the docket, Your Honor.
My number is 2102-5939.
Jennifer Lacedo?
Claveau.
I'm sorry?
No, 2102-59. What's the name you said?
Latanya Bastio.
5939. Is she bond?
Okay, looking now. Yes, bonded.
Okay, Ms. Clavel, do you understand English, ma'am? Would you like an interpreter? Okay, in what language? Okay, let's get the interpreter on the line. They're gone? Okay, we'll try to get the interpreter.
Hello, Cisco Unity Connection Messaging System. From a touch.
Do you understand English? So if I speak and you do not understand, please just let me know, okay? You have the right to remain silent. Anything that you say may be used against you. You have the right to speak with counsel, family, and friends. You have the right to an attorney. Would you like me to appoint the office of the public defender to represent you? Okay, at this time, I am going to appoint the office of the public defender to represent you. I am finding that there is probable cause. I am going to enter the bond amount of $15,000. It's the, oh, I'm sorry, I don't know if I told you, ma'am, that the charge that you are charged with is possession of cocaine with intent to sell, okay? In addition, ma'am, you are to have no illegal substances. Do you understand?
And Judge,
Yes.
we would just be asking for a bond reduction in light of the very minimal criminal history. There's a pretty large discrepancy between the scheduled amount for possession with intent as opposed to just simple possession, 15,000 versus 1,000. Given the nonviolent nature coupled with the lack of history, we'd be asking for something in the realm of 2,500.
State?
I think generally our policy towards drug possession is a little bit less strict, so I wouldn't object to what's been proposed by counsel.
Pretrial release?
No, nothing, Your Honor.
Okay, I'm going to set the bond amount in the amount of $5,000. It does, it's not a simple possession charge. There's probable cause to support possession with intent to sell. I'll set the bond amount at $5,000 with no, you may have no illegal substances. Do you understand, ma'am? Have a nice day, ma'am.
Here you go.
The Sheriff Cook, is bonded, Your Honor.
Please state your name for the record?
Nadia Dawson.
Good afternoon, Ms. Dawson. You are here for a first appearance for the charges of possession of methamphetamine, possession of cocaine, and possession of cannabis. You have the right to remain silent. Anything that you say may be used against you. You have the right to communicate with counsel, family, and friends, and you also have the right to an attorney. Would you like for me to appoint the Office of the Public Defender to represent you?
Yes.
Okay, at this point, I will appoint the Office of the Public Defender to represent you. Further, I am finding that there is probable cause in this case. Let me see here. One moment. Okay, I am going to set the bond amount on possession of methamphetamine at $1,000. On possession of cocaine, I'm going to set it at $150. For possession of cannabis, I'm going to set the bond amount of $100. I think there's a second case, is that correct?
Yes.
Okay, so the second case that you're also, I'm sorry? No, I thought I heard something. Okay, the second case is driving with a suspended license. If I recall, it's the same, let me see. The same, based on the same affidavit, correct?
Yes,
Okay. I think my notes were a little unclear. I'm finding probable cause to support that charge as well. Your bond in that case on the charge of driving with a suspended or revoked license is going to be $500. You are to have no illegal substances. Do you understand that, ma'am? That's a condition of your bond. Okay. Have a nice day, ma'am.
Cause, document, mental health, Your Honor.
Is it not Galloway next?
Well, before that, where we have document, but
What do you have for Galloway?
document, call
Dockman.
document.
He was on the move up list, Your Honor.
Yeah,
We took care of him.
Oh, we already did. Yeah, we already did.
Yes, Your Honor.
Okay, who's next?
This Galloway. Yeah, Galloway's in it. Mr. Galloway should be next. That document was in the move up.
Sir, will you state your name for the record?
Byron Galloway.
Okay. All right. Mr. Galloway, you are here for a first appearance on the charge of failure to appear. You have the right to remain silent. Anything that you say may be used against you. You have the right to communicate with counsel, friends, and family, and you have the right to an attorney. Would you like for me to appoint the Office of the Public Defender today? Okay, I will appoint the Office of the Public Defender to represent you, sir. I am finding probable cause on the record, sir, and then also there has been a capias issued for you. The underlying charge is possession of Udalone, and the capias has set bond at none. So at this time, I am going to hold you with no bond. Have a nice day, sir.
Your Honor, Mr. Hodges, mental health.
Mr. Hodges in mental health. Could we waive his appearance and go forward, counsel? Is that something that's...
I'm comfortable with that, given the nature of the facts.
Okay, and that's Mr. Hodge?
Yes.
Okay. Okay, so you're waiving, I'm appointing the public defender today and you waive his initial appearance?
Yes, Your Honor.
Okay. And he is here on the charge of criminal mischief. Bond has been set in the amount of $1,000 originally. Let's see. I am finding that there is probable cause in this case. Would defense like to be heard on bond?
No, Judge.
Okay. All right. I will set bond in the amount of $1,000. with no additional conditions. Oh, actually, there is going to be an additional condition based on my notes. There to be no illegal substances. Are you Mr. Hoover, sir?
Yes, ma'am.
Okay, would you please state your full name for the record?
Dennis Dwayne Hoover.
Mr. Hoover, you are here for a first appearance for the charge of grand theft of a motor vehicle. You have the right to remain silent. Anything that you say may be used against you. You have the right to communicate with counsel, family, and friends. You also have the right to an attorney. Would you like for me to appoint the Office of the Public Defender to represent you?
Yes.
Okay, at this point, I will appoint the Office of the Public Defender to represent you today. I am finding that there is probable cause in this case. I am going to set the bond amount at $500. Have a nice, oh.
Okay. Yes, sir.
Done?
Yes. Okay.
Your Honor, Eddie Jackson bonded.
One moment, please. Okay, and so Eddie Jackson bonded?
Yes.
Okay, I think he had 2 cases, yes?
There was, in charge of that name of doctor.
All right, sir, would you please approach?
Your Honor, Johnson Marcus behavior.
Okay. Counsel, is there any reason I can't appoint the public defender and waive initial appearance?
I'm not objecting if the court finds a waiver, Your Honor. Based on the refusal.
Based on the refusal?
Yes, I'm not objecting to the finding that he's waived his appearance here.
Oh, because it's behavior. Okay, one moment. Okay, at this point in time, for Marcus Trey Johnson, I will find that the appearance is waived and appoint the Office of the Public Defender. We're here for a first appearance. It looks like the charge, there was an arrest warrant for the charge of grand theft in the 3rd degree. I am finding probable cause to support that. It looks like probable cause in addition was already found. Bond was set in the amount of $500 by Judge Young. I will keep that bond amount of $500. And then was he already out, counsel, on bond for possession of methamphetamine, resisting an officer without violence, and possession of drug paraphernalia?
Yes, Judge.
Okay, so at this point, I will revoke the bond on those counts. What's that? Oh, okay, and then in addition, I am ordering as to the grand theft count that there be no contact with the alleged victims and that he does not return to the location of the alleged offense. I revoke the bond on the other 3. Sir, will you approach and tell us your name, please?
Your Honor.
Yes.
Mr. Harold Jones is in the hospital.
Also, there's another case on the methamphetamine case on Marcus Johnson.
Thank you. Okay, so it's still Marcus Trey Johnson. The charge is possession of methamphetamine. One moment. At this time, I am finding probable cause. I will set the bond amount in the amount of $1,000. In addition, he is to have no illegal substances.
Your Honor, there was also Harold Dwayne Jones before this gentleman.
It's in the house. Mr. Jones is in the hospital.
The hospital. I have a first appearance detainer for him also. I put a copy of it with your papers for.
Okay, what happened with, Johnson, 2102-5948?
The person we just were talking about?
Different Johnson.
Let's go off the record really quick.
Taiwan?
Okay, we're back on the record. So the next is Harold Dwayne Jones Jr., and he is in hospital. Okay. At this point, I'm going to appoint the Office of the Public Defender. Any reason that I cannot do that today, counsel?
No, Judge.
Okay, so I'll go ahead and appoint your office to represent him. And are you waiving initial appearance on his behalf?
I'd rather not, Your Honor. Just given the fact that he's in the hospital and he has an out on bond case.
Okay.
I think that he might be a little too confused. Yeah, and I think he needs to know the conditions. Yeah, that's.
Okay, we will reset for Mr. Jones. Sir, are you Brandon Ryan Moats?
Yes, sir.
Okay, would you please state your name for the record? Okay, Mr. Moats, you are here for your first appearance on the charges of grand theft in the 3rd degree, as well as resisting an officer without violence. You have the right to remain silent. Anything that you say may be used against you. In addition, you have the right to communicate with counsel, family, and friends. You have the right to an attorney. Would you like me to appoint the Office of the Public Defender to represent you today? Okay. At this point, I will appoint the Office of the Public Defender to represent you. In addition, I am finding probable cause in this case. As for grand theft in the 3rd degree, I am setting the bond in the amount of $1,000. For resisting an officer without violence, I am setting a bond amount of $500. You are not to have any illegal substances as a condition of your bond. Let's see. And you may not have any contact with the alleged victim. Do you understand? Have a nice day, sir. Sir, will you please state your name for the record?
Yes, Matthew Purley.
Mr. Purley, you are here for a first appearance on the charges of possession of methamphetamine, possession of cocaine, and possession of drug paraphernalia. You have the right to remain silent. Anything that you say may be used against you. You also have the right to communicate with counsel, family, and friends. You have the right to an attorney. Would you like me to appoint the Office of the Public Defender to represent you?
I would, yes.
At this time, I will appoint the Office of the Public Defender to represent you today. As to the charges of possession of methamphetamine, possession of cocaine, and possession of drug paraphernalia, I am finding that there is probable cause to support the charges. In addition, I am setting a bond amount on the possession of methamphetamine for $1,000, a bond amount of $150 on possession of cocaine. As for possession of drug paraphernalia, I'm setting the bond in the amount of $100. In addition, am I correct that you are presently out on bond for driving while license revoked as a habitual offender?
That's correct, Your Honor, and just brief argument as to that point.
Okay.
We would just be asking that the court take no action on the out on bond case. Based on the affidavit in the new case, Mr. Purley was extremely cooperative with law enforcement. Additionally,
In the new case, counsel?
yes, in the new case. And Mr. Purley was stopped on a basis of having no lights on his bicycle. There may be some constitutional issues down the road. So I'm asking that the court take no action on the out on bond case.
Okay, one moment, please. Would the state like to be heard?
I think maybe not in the presence of another defendant, and speaking about the details of this case.
I'm sorry, say that one more time.
Yeah, maybe not in the presence of another defendant, in speaking about the details of this case.
Okay, can we remove the other defendants so the state can be heard?
Yes, so I mean, with cooperation, we're talking about providing information with regard to who he had purchased the narcotics from.
Essentially.
Essentially, yeah. Your Honor, I think taking that in mind, that we wouldn't object to having no action taken with respect to his prior bonded case.
Okay, so I'll take no action today on the original bond that was issued on the driving while license revoked. I've already set bond on the other charges of possession. In addition, sir, as a condition of that bond, you are to have no illegal substances. Do you understand? Okay, have a nice day, sir. Sir, would you please state your name for the record?
Brandon Sanguine.
Mr. Sangwin, you are here for a first appearance on the charges of possession of cocaine and possession of drug paraphernalia. You have the right to remain silent. Anything that you say may be used against you. You also have the right to speak with counsel, family, and friends. You have the right to an attorney. Would you like me to appoint the Office of the Public Defender to represent you?
Ma'am.
Okay, at this point, I will appoint the Office of the Public Defender to represent you. I am finding that there is probable cause in this case. One moment, please. Okay, at this point, as to the charge of possession of cocaine, I'm setting a bond in the amount of $1,000. As to possession of drug paraphernalia, I am setting bond in the amount of $500. In addition, as a condition of your bond, you may have no illegal substances. Do you understand?
Ma'am.
Okay, have a nice day, sir. Sir, will you please state your name for the record?
Ray Jerome Styles.
Mr. Stiles, you are here for a first appearance for the charges, wait, one moment, let me just count my pages. For the charges of fleeing and eluding, grand theft in the third degree, and resisting an officer without violence. You have the right to remain silent. Anything that you say may be used against you. You also have the right to speak with counsel, family, and friends. You have the right to an attorney. Would you like for me to appoint the Office of the Public Defender today?
Yes, ma'am.
Okay, I will appoint the Office of the Public Defender to represent you. Based on my review, I am finding probable cause. Let's see. Okay. As to the fleeing and eluding charge, I'm setting bond in the amount of $15,000. As to grand theft, I am setting bond in the amount of $1,000. And as to resisting an officer without violence, I am setting a bond in the amount of $100. Let's see. In addition, you are to have no illegal substances as a condition of your bond. You are to have no firearms. Do you understand? If you have firearms, they need to be surrendered to law enforcement. Defense, it looks like he was, if I'm correct, he was out on bond for carjacking and fleeing and attempting to elude an LEO.
My paperwork reflects that also, Your Honor.
Okay, would you like to be heard?
We would just ask the court to take no action based on the fact that the state has not filed charges on that case at this point.
They haven't filed charges on the carjacking and fleeing and eluding?
Correct.
State?
I think it would be appropriate to revoke in this case, Your Honor. I mean, despite the fact that it hasn't been filed on.
Is it out of time to be filed?
Let me review. It's not out of time to be filed, Your Honor.
Okay, at this point, I am going to revoke the bond on the other case. I've already set the conditions for bond on the new case and the amounts. Have a nice day, sir.
Okay. All right, thanks.
Thank you.
And just for the record on Stiles, Your Honor, RCC is appointed on the out on bond case, so we would not want the PD appointed to that.
Oh,
Just the new one.
on the new case?
Yes.
Okay. Sir, would you please state your name for the record? Mr. Vasquez Camacho? Okay. Do you understand English, sir? Okay. Sir, you are here for a first appearance for the charge of driving while license revoked as a habitual offender. You have the right to remain silent. Anything that you say may be used against you. You also have the right to speak with counsel, family, and friends. You have the right to an attorney. Would you like for me to appoint the Office of the Public Defender to represent you at this time? Okay, at this time, I will appoint the Office of the Public Defender. I see you nodding your head. I am finding that there is probable cause to support the charge. It looks like you were also out on bond at the time of the offense for driving while license suspended. Okay. Does the defense want to be heard at all?
No, thank you, Your Honor.
Okay, all right, so at this time, on the charge of driving while license revoked as a habitual offender, I am setting bond in the amount of $2,500. I am revoking bond on the other charge. You are to have no illegal substances as a condition of the bond. Do you understand? Have a nice day, sir.
There you go.
Sir, will you please state your name for the record?
Azarovella. Azarovella.
Is it Mr. Vela?
Yes, ma'am.
Okay, sorry, I was having trouble hearing you. Mr. Vela, you are here for your first appearance for the charges of burglary of a conveyance, burglary of a conveyance, burglary of a conveyance, and then 3 charges of petty theft. Just one moment, please. I am probable cause. You have the right to remain silent. Anything that you say may be used against you. You also have the right to communicate with counsel, family, and friends, and you have the right to an attorney. Would you like for me to appoint the office of the public defender to represent you today? Okay, at this point, I will appoint the office of the public defender to represent you. In addition, I am finding that there is probable cause in this case. Another judge previously found a probable cause. I am going to set your bond on count 1 in the amount of $3,500. On count 2, $150. On count 3, $150. On the 4th count, which is petty theft, $150. On the 5th and 6th counts, which are both also petty theft, the bond amount will be $150. In addition, sir, you are to not return to the alleged scene. Do you understand that? You may not return there, and you may have no contact with any victim in this case.
Judge, because this was a warrant case,
Yes.
he does not know that address. I don't think he's been given a copy of the
Okay.
warrant, and I don't have it.
Okay, one moment. Thank you, counsel. It's not set forth, he can't see it in the warrant, counsel?
We just, we don't have the affidavit to issue.
Oh.
So he doesn't know the address of the location where he can't return.
I'm looking up the case now, Your Honor, to see if I can find it.
I mean, I have it.
Oh, okay.
I'll write it down for him if we can just.
Okay, it was alleged to have occurred at 34 West 13th Street in Apopka.
Thank you, Your Honor.
The alleged victim with whom you may not have any contact is Bartha Barajas. It's lengthy. Let me just, because there are several counts. Okay, the other address is 38 West 13th Street.
Thank you, Judge.
One moment, I think there might be another one. And 42 West 13th Street.
You're all set. That's it for now.
In addition, sir, you are to have no contact with Fernando Lopez Reyes.
This is a complete roommate. It's complete. This person was living in the street. He was married to Carlos.
Do you understand, sir?
Yeah, there's no other Hispanics there.
Just not in. Yeah, absolutely.
All right.
Have a nice day, sir. Sir, would you please state your name for the record?
Emmanuel Lewis.
Good afternoon, Mr. Lewis. You are here for your first appearance for the charge of, there are 2 charges of failure to appear. You have the right to remain silent. Anything that you say may be used against you. In addition, you have the right to communicate with counsel, family, and friends. You have the right to an attorney. Would you like for me to appoint the office of the public defender to represent you?
Yes, ma'am.
Okay, at this point, I will appoint the office of the public defender to represent you in this case. Let's see, it looks like the original offenses were resisting an officer without violence and trespass. There has been a capious, let's see, one moment. I am finding probable cause. There has been a capias entered in the amount of $600. That's $500 on resisting an officer without violence and trespass in the amount of $100.
Thank you, Judge.
Okay.
Does pretrial have a county listed as a hold?
There's an out-of-county hold for Lafayette County, and that hold is for, looks like failure to appear on a Dwellis 548.
Yeah. Are there
$548 bond, sorry.
548?
Yes, strange number, but that's what's in there.
Thank you.
Welcome.
Yeah, this is orange. Mhm.
Also to reflect council, cash bond only on that one, what it says.
Oh, on Lafayette. Thank you for
You're
clarifying.
welcome.
Mhm.
Have a nice day. Sir, will you please state your name for the record?
Michael Allen.
Oh. It's not who I have. Okay, where are we? One moment, Mr. Allen. With Carrasco? You don't have it in the.
2102 5925.
Christina Carrasco, she bonded.
Okay, thank you. Okay, Mr. Allen, you are here for your first appearance for the charge of larceny, petty theft in the second degree, a third offense. You have the right to remain silent. Anything that you say may be used against you. You also have the right to speak with your counsel, your family, and your friends. You have a right to an attorney. Would you like me to appoint the Office of the Public Defender to represent you?
Yes.
Okay, at this point, I will appoint the Office of the Public Defender to represent you in this case. I am finding that there is probable cause. I am setting your bond amount for the petty theft in the amount of $1,000. In addition, sir, you are not, excuse me, one moment, please. One moment, please. You are not to return to the Old Navy store. Do you understand that, sir?
Yes.
Okay. Defense, did you want to say something?
Yes, thank you, Your Honor. Mr. Allen's informed me he's not able to afford monetary bond. I see that he has not been qualified for PTR. Defense would be moving for ROR, given the nonviolent nature of the charge and the statutory presumption in favor of non-monetary release.
Reason for no PTR, Your Honor, is a warrant out of Georgia for FTA disorderly conduct with no extradition. But we did not qualify him for PTR.
Does he qualify for ROR in your mind?
On the booking floor, we would have because of his history with 3 felonies, 5 misdemeanors, 2 fair to fears. But in court, it's a felony charge, so it would just be up to Your Honor.
Thank you. State?
No position, Your Honor.
If he doesn't qualify, counsel, do you want to make an alternative request or leave your argument?
I'm sorry, if he doesn't qualify.
For the PTR, and if I don't do the ROR because of his history?
Then I would just leave it there, Your Honor.
Okay, one moment, please. Okay, I'm going to reduce the bond amount to $750. And again, sir, you are not to return to the store. Do you understand? Have a nice day, sir. Yes.
I apologize, Judge. I didn't realize He is taking chemotherapy. I don't know how often, but he wanted that to be part of your consideration. I just didn't know that when I made the argument. I don't know if that would change the court's ruling.
I'm sorry to hear that, sir. I have other items that I need to consider when determining bond. I am sorry to hear that. I'm going to leave your bond as it is and the conditions as it is. Good luck to you, sir.
Just I have to pay to get out.
100.
This one.
Jennifer Potter's behavior.
Jennifer Potters. All right, one moment. You don't have Camonte Phillips next?
102-5951.
Yes, bonded.
Counsel, does your office wish to be appointed on behalf of Ms. Potter?
Yes, Judge.
Okay, I'll go ahead and appoint the Office of the Public Defender to represent Jennifer Eleanor Potter. Do you waive her initial appearance?
What was the? Yes, Your Honor.
Okay. All right, at this time, she is otherwise here. She is set for initial appearance, at least on the charge of trespassing of an occupied structure or conveyance. I am finding that there is probable cause. I'm entering a bond in the amount of $500, and I am ordering that she cannot return to that property and is to have no contact. One moment, please. With the manager of that restaurant. Anything further, counsel?
No, Your Honor.
Okay. All right, and it looks like next is Nathan Martin.
He refused, Your Honor.
Sorry?
He refused.
He refused. Okay, we'll just reset him.
Yes, Vincent Whitehead?
Yes.
Yes, he's mental health.
Counsel, do you feel comfortable? He's in mental health.
Yes, Judge. We can waive.
Okay, at this time, I will appoint the Office of the Public Defender to represent Gerald White. He's here, or are you waiving the initial appearance?
Yes, Your Honor.
Okay, and he was here, or he is set for first appearance today for the charge of grand theft in the third degree. One moment, please. Oh, he's a reset? Yes. Okay, I am finding that there is probable cause in this case. I am setting a bond amount in the original amount of $1,000. And I'm finding that he is to have no contact with the alleged victim. He is also not to return to the scene. You may approach, sir.
Kimberly Charizard, bonded.
Sir, will you please state your name?
Joshua Lee Dixon.
Mr. Dixon, you are here for a first appearance. It looks like you have been charged with a violation of probation today. You have the right to remain silent. Anything that you say may be used against you. In addition, you have the right to communicate with counsel, family, and friends. You have the right to an attorney. Would you like for me to appoint the Office of the Public Defender to represent you?
Yes, ma'am.
Okay, at this point, I will appoint the Office of the Public Defender. I am finding probable cause in this case. And it's a violation of probation, so you are going to be held at no bond.
Yes, ma'am.
Anything from the defense?
No, Your Honor.
Okay. Have a nice day, sir. Sir, will you please state your name?
Gary Reeves.
Mr. Reeves, you're here for a first appearance. The charge is violation of probation. The underlying offense was burglary of a dwelling. You have the right to remain silent. Anything that you say may be used against you. In addition, you have the right to communicate with counsel, family, and friends. You have the right to an attorney. Would you like for me to appoint the office of the public defender to represent you?
Yes, ma'am.
At this point, I will appoint the office of the public defender to represent you today. Based on my review, I am finding that there is probable cause in this case. Counsel, do you want to be heard?
No, Your Honor.
Okay. At this point, it's a violation of probation. I am going to hold you with no bond. Have a nice day, sir. Good afternoon, sir. Would you please state your name?
Area Smalls.
Mr. Smalls, you are here for a first appearance for the charge of violation of probation. You have the right to remain silent. Anything that you say may be used against you. In addition, you have the right to speak with counsel, family, and friends. You have the right to an attorney. Would you like for me to appoint the office of the public defender to represent you? Okay, I see you nodding yes. I will appoint the office of the public defender to represent you. I am finding probable cause in this case. Defense, would you like to be heard?
May I have a moment, Your Honor?
Yes. I'm sorry? Oh, yes, it is right here on my notes. Heard.
Judges, is there a $5,000 bond set on this?
There is, yes, counsel.
Okay, great.
Okay, so I'll keep that bond at $5,000. In addition, sir, as a condition of that bond, you are to have no illegal substances. Do you understand? Okay, have a nice day, sir.
Oh, it just has to process.
With weekends excluded.
Is that accurate?
Weekends excluded on the violent felony offender or special concern, yeah.
Sir, would you please state your name?
Pratt Ronald Lee.
Mr. Pratt, you are here for a first appearance on the charge of camping in an area where it's prohibited. You have the right to remain silent. Anything that you say may be used against you. You have the right to speak with counsel, family, and friends, and you have the right to an attorney. Would you like for me to appoint the office of the public defender to represent you?
No, ma'am.
Okay, do you have another attorney that you would like to represent you?
No, ma'am.
The woman next to you today is with the office of the public defender. Do you know that?
Yes, ma'am.
But you do not wish to have an attorney?
I don't know. I'm guilty. That's all I can tell you, ma'am.
Okay, sir, please be mindful. Anything you say may be used against you.
Yes, ma'am.
I can't appoint if you say yes. If you say no, that's within your rights. But if you say yes, I can appoint her to represent you.
Yes, ma'am.
Okay. At this point in time, I will appoint the office of the public defender to represent you. Does the state have anything on this case that you'd like for me to consider?
No, Your Honor.
Okay. I am finding probable cause. Would the defense like for the court to consider anything?
Yes, Judge. I have serious concerns about the municipal ordinance even being constitutional. I recognize that this is not the appropriate place to raise that argument, but I do think in terms of conditions of release, the court should consider that many appellate courts, federal and state around the country, have recognized that it's not lawful for municipalities to criminalize being homeless. Mr. Peratt was sleeping under a blanket on the street when he was arrested, so we would just ask for ROR. Additionally, and please correct me if I'm wrong, I don't think the state is actively prosecuting cases like this with their new policies.
No, we're not. The state is not.
Do you want a moment to confer, counsel?
I mean, to confer with defense counsel or?
Yes.
Yeah, okay, yeah, sure. Yeah, Your Honor, I mean, I'd want to hear from PTR regarding, what the recommendation should be in this case. I would just second with counsel. Prosecuting these kinds of cases isn't something that the state attorney's office is really focused on or actively prosecuting. But I would like to hear from PTR though.
I could speak on the PTR. We didn't qualify him because of history and his community ties. Whatever the state and the public defender would come up with be fine with pretrial.
And Judge, I just noticed that the paperwork says he's a combat veteran with an honorable discharge. Is that right?
Yes, ma'am. Marine Corps.
Thank you for your service, sir.
My pleasure, ma'am.
Okay, with that, Your Honor, we wouldn't object to ROR in this case.
One moment, please. Okay, at this point, I will go ahead and order ROR in this case.
Thank you, Your Honor.
Have a nice day, sir.
Thank you, ma'am.
Please state your name for the record, sir.
Sir Eric Stephen Romero.
Mr. Romero, you are here for a first appearance for the charge of disorderly conduct. You have the right to remain silent. Anything that you say may be used against you. In addition, you have the right to communicate with counsel, family, and friends. You have the right to an attorney. Would you like me to appoint the Office of the Public Defender to represent you?
Sure.
Okay. At this point, I will appoint the Office of the Public Defender to represent you in this case. I am finding that there is probable cause. One moment, please. Did pretrial release want to let me know anything?
Your Honor, we did not interview him, but we do have his history, his prints are back, and I see that he has arrests, but no convictions. So if you wanted to set bond for him or do PTR if qualifies as an option through PTR if you'd like, or that we'd have a way out either way. If we couldn't get what we need downstairs from him, he could still bond out on that. It is a misdemeanor pleadable charge. I don't know if they talked about deals or anything, but or RORs.
State, any input?
I don't think we'd even be dealing with this. Probably be handled by the city. I'm not sure if I would even have the ability to make an offer in this case.
I'm sorry, you didn't understand. I'm sorry. Just go toward the microphone for me.
Yeah, sorry. I'm not sure that, I think this would be handled by the city prosecutor and not something that I could make an offer on. It's my understanding.
And do you have any objection to the PTR?
No objection, Your Honor.
What would the defense like me to consider?
Bond or PTR, like pretrial suggested.
Okay, at this point, having found probable cause, I'm going to set bond in the amount of $250 with the screening for PTR to be conducted in the event he qualifies for the pretrial release. Then that is what my order is going to be. In the event that he does not qualify, bond will be set in the amount of $250. In addition, sir, you're to have no contact with the victim. Do you understand?
Yes.
Okay.
I
The alleged victim.
don't know who it is. Yeah.
Oh, okay. Well, then let me not order that if you don't know who he is. So I'm vacating that. Strike that.
Any special conditions for that, Your Honor? For the disorderly conduct? No special conditions?
No.
Okay.
His behavior?